Mr. Rahmani,
Good morning.
welcome to the inquiry. Let me explain our arrangements. But first of all, I understand that because your surname is mispronounced so often, you prefer to be known as Brian.
Correct.
Very good name. You're talking not just to the assembled company in front of you, who are a mixture of participants and core participants, and potentially in a room beyond this hearing room, a breakout room, but also online to those who are watching either on YouTube or on live stream. So the audience for what you have to say will number in 3 figures, most probably. The questions will be asked by Ms. Richards in a moment, though first Mary will invite you to take the oath. Mary.
Okay.
Please state your full name.
Brian O'Mahony.
Take the book in your raised hand and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Brian, I'm going to start with an overview of your career. You are the current Chief Executive of the Irish Haemophilia Society,
That's correct.
and you've held that position since 2006.
Correct.
But your involvement with the Irish Haemophilia Society dates back to the early 1980s.
1982.
And you've been on the board since 1982, other than for a brief period in around 2003-04. You were chairman of the Irish Haemophilia Society between 1987 and 2003.
Yes.
Between 1994 and 2004, you were president of the World Federation of Haemophilia.
Yes.
And between 2011 and 2019, you were president of the European Haemophilia Consortium.
Yes.
You yourself have severe haemophilia B.
Yes.
And you're a medical laboratory scientist by background and training.
Correct.
And that's the capacity in which you worked until 1994.
Correct.
Now, you've sat on multiple committees and boards relating to haemophilia, including for a period of time the Irish Blood Transfusion Service Board.
I still sit on that board, in fact.
And you've set those out in your witness statement, paragraph 3. I'm not going to go through them all, but there's a significant number in terms of your involvement. In relation to previous inquiries, you gave evidence at the Institute of Medicine inquiry in the USA in 1994.
That's correct.
And what, in very broad terms, was the nature of your evidence?
The nature of my evidence at the IOM inquiry was related entirely to the response of governments outside the USA. So they wanted some comparative statistics and data. So really I was looking at the response in other countries.
And then you gave information to the Royal Canadian Mounted Police in 1995 in the course of
That's correct.
of a visit that was taking place in Canada, not for that purpose.
That's correct.
You were involved in the Finlay and the Lindsay Tribunals of Inquiry in Ireland. And just so that we understand the difference between the two, the Finlay Tribunal focused on infection through anti-D and also blood transfusion. And the Lindsay inquiry looked at the infection of people with haemophilia.
That's correct.
And you gave evidence to the Lindsay Tribunal twice.
Yes.
And you then gave evidence to the non-statutory inquiry, the Archer inquiry in this country.
Yes.
I'm not going to ask you in any detail about your work in Ireland in the 1980s and 90s, but just so that we can understand the position of the Irish Haemophilia Society at that time, it was, as I understand it from your statement, a very small voluntary organisation, and in the early 80s it didn't have an office or even a permanent address.
Yeah, when I joined the board in 1982, the society had a voluntary committee, no office, no staff, no headquarters. In fact, whoever the unfortunate individual was who happened to be honorary secretary, all the mail arrived at their house. So the annual budget at the time was around £4,000.
And it was, I think, 1987 before there was any kind of staff member at all.
We had a part-time member of staff two mornings a week from 1987, and our first full-time staff member in 1989.
And then I just wanted to ask you briefly about your own knowledge of AIDS back in the 1980s and how you came to be aware of the possibility of a risk of transmission through blood or blood products. Your statement indicates that came to the attention of the Haemophilia Society in Ireland in 1983.
Correct.
And you yourself learnt about it through reading an article in a laboratory magazine,
Yes.
so through your own scientific
Yes.
work. Do you have any recollection of roughly when in 1983 that might have been?
March or April of 1983.
And then it was, I think, following a newspaper article, and you've referred, I think, in your statement to the Killer Blood article, which I think dates it from our purposes to the Mail on Sunday article at the beginning of May 83. You then had a meeting with the Irish Blood Transfusion Service.
That's correct.
There was a suggestion that you discussed the issue with someone you've described in your witness statement as the treating consultant. Would it be right to understand that's Professor Temperley that you
Yes.
were talking about there? And again, just so that others can understand your statement, what was his role?
Professor Temperley was the National Haemophilia Director, so he was the director of the main National Haemophilia Treatment Centre in Dublin at the time. The discussions I had were with Sean Hanratty, who was the Chief Scientific Officer of the Blood Transfusion Service Board, and my meeting with him, which I actually took a handwritten minute of, was based on the fact that I was concerned that there seemed to be little or no progress being made in relation to self-sufficiency for factor concentrates from Irish plasma. And I was, I had this idea in my head that if we were self-sufficient, there would be a lower risk of transmission of potentially blood-borne viruses.
In your witness statement, if we just have it up on screen, WITN 7418001, please, Lawrence. And if we could go to page 5. If we pick it up top of the page, is this paragraph 7 of your statement? You've said,
Yes.
In his replies to us, and the context in the previous paragraph was the discussions you've referred to in 1983, the treating consultant pointed out that all blood products could potentially cause AIDS or non-A, non-B hepatitis, and that the risk of bleeding was much greater than the risk from any viral infection. Do you have any recollection of when in 1983 that was being said, roughly, by the treating consultant?
That would have been around, I think, May or June of 1983, shortly after my meeting with the Blood Transfusion Service.
And then just one other request for clarification from your statement. If we go over the page to page 6, please. Paragraph 9, you report that in December 1984 we had the first diagnosis of AIDS in an Irish person with haemophilia. And then this, the indication from the treating consultant at that time was that this may be the only case of AIDS we would see in a person with haemophilia, and that perhaps only 1% of those who were HIV positive would go on to develop AIDS. Do you know whether any reason was given for that rather optimistic prediction that it might be the only case of AIDS?
I think it seemed to be very much the prevailing clinical opinion at the time. Professor Temperley would have had a close relationship with the UK HCDO, attended their meetings. If you look at similar talk from people like Dr. Peter Jones in his book in 1985, he talked about 1.5%. So initially the advice was very much that to stop taking factor concentrates was much more dangerous because of the risk of bleeding than the potential risk of a potential blood-borne virus. By the end of 1984, when we had the first case, I remember Professor Temperley saying very clearly that he expected this would be the only case we would see, that the risk of people who were HIV positive going on to develop AIDS was probably 1%.
Can I then just ask you, in terms of the numbers of people with haemophilia in Ireland and numbers infected, if we look at a document you've exhibited to your statement, it's WITN 7418004. And we can see it's entitled AIDS Haemophilia in the Government, a submission from the Irish Haemophilia Society calling for financial provision for people with haemophilia infected with the AIDS virus, and the date is April 1988. And if we could go to page 3, please, Lawrence. We've just got some figures on the right-hand side of the page.
Yes.
Third paragraph. Of the 296 haemophiliacs registered in Ireland, 265 have been tested for exposure to HIV, 106 have been infected with HIV, 9 had developed full-blown AIDS, 4 by that time had died. 70% of severe haemophilia A patients have been infected. The 296 haemophiliacs registered in Ireland, did that encompass, as far as you understand it, those who were mild, moderate and severe?
No, look at the numbers, that would probably have been moderate and severe.
And then we have the figures there, 106 infected with HIV, so 40%. And does that remain the figure, as far as you know, the numbers infected
Yes.
with HIV?
Yes.
And then in terms of the numbers infected with hepatitis C, do you have any knowledge of what proportion were infected with hepatitis C?
Talking about 240, 245 people.
So a very significant proportion.
Yes, but also that would have encompassed a number of people with mild haemophilia as well.
Understood. We can take that down, thank you. I want to ask you now, Brian, about some of the measures that have been put in place over the decades in Ireland to address the needs and the circumstances of those who were infected through blood and blood products. The purpose, as I know you understand, being for us to understand whether there is anything that can be learnt from how Ireland has responded to the plight of those infected. So I wanted to start with the Haemophilia HIV Trust. As I understand your statement, Brian, this emerged following, first of all, a survey that the Irish Haemophilia Society undertook of its members in 1987. Is that right?
Yes, I became chairman of the society in 1987, and my top priority was helping our members who had been exposed to HIV and who had developed AIDS. So in order to understand what their real requirements and needs were, a dental surgeon and I, who sat on our board as well, we did a survey of as many people as possible who had HIV and AIDS. So I think we got 58 responses out of 70 surveys sent out, and that allowed us to draft up this proposal for government based on a real understanding of what their needs were.
And that resulted in that submission that we looked at briefly
Yes,
a couple of minutes ago. And the argument that was being made at that point in time, as I understand it, was that there was a moral responsibility on the government
Yes.
to respond to the situation of those who've been infected through no fault of their own with HIV.
Yes.
That wasn't accepted by the government to start with, and the society embarked upon a public and political campaign.
I mean, when you say it wasn't accepted, all we received actually was an acknowledgement of receipt of the document and then 5 months of silence. And despite the fact, I was naive enough to think at the time that if you sent in a well-reasoned, well-argued case, that it would receive a fair response from the Department of Health. That didn't happen. So at the end of that year, people were getting sicker and they were dying. So we realised we had no option really but to try and put political and media pressure on the government to respond to this.
Now, that resulted eventually in an agreement which led to the establishment of the Haemophilia HIV Trust.
Yes.
Did you? What was your understanding of what ultimately persuaded the government to accede to that?
Well, the fact that the political media campaign was very successful, we got a lot of traction, a lot of media coverage. We had some of our members with HIV who spoke publicly and very bravely to highlight the issue. And then it went all the way to, we had a minority government at the time, it went all the way to a vote in the Parliament. The week before the vote, I had assumed the government would offer some sort of compromise. We spent the week in discussions. The government didn't move whatsoever on this. They made it an issue of financial management, so that when they then threatened that if they lost that vote in the Parliament, they would call an election. So the Prime Minister lost the vote in the Parliament, called a general election, lost seats in the election, and fortunately in the course of the election campaign, we had received written commitments from the leaders of all the other parties to implement a trust fund if they got into office. The Prime Minister, the outgoing Prime Minister, then had to go into coalition with another party, And as part of the negotiations for the programme for government, the trust fund was established.
Now, initially, that trust paid regular payments. So from about 1987 to 1991, there was some regular payments.
1989 to 91. It was established in 89, and we made regular payments to some individuals, not to all individuals. It was very much based on an assessment of individual need and people's individual circumstances. And people really were struggling. Some people were really struggling. So regular payments were made to those who needed them until 1991, when in fact a further tranche of compensation was paid.
And those are the ex gratia payments, essentially,
yes,
from 1991, and we'll pick up those in a moment. If we then just staying with the Haemophilia HIV Trust, from 1991 onwards, it was one-off payments.
Yes.
So it might be for funeral grants or equipment, those kind of
yes.
Hospital
needs. Beds, wheelchairs, any special mattresses, anything that would be required by the person with HIV or AIDS to help them to deal with the condition, and certainly one-off items which would not easily be provided in any sort of timely manner through the health service.
And what you've told us in your statement is that the way it was designed to operate was that it didn't have overly complex procedures or requirements for lots of different type of proof. The individual would communicate with the trust. It might be by letter or by telephone, and a decision would be made as to whether to make the payment. And it was designed to be done as quickly as possible. Is that right?
Yes, it was very non-complicated. I think the society had people on the board of trustees with independent trustees. So a request would come in for funding. It may be based on a phone call, maybe based on a letter, and then that would be discussed very, very quickly and decision made. In some cases where it was a very urgent situation and the request came in directly to the Irish Haemophilia Society, we would pay the item ourselves and then seek to recoup the money later from the HHD. If you look at our audited accounts for all the years from 1989 to now, there's always an in and out from HHD, and they never match up because typically there can be a couple of months delay before recouping the money back. But it's always been our view that the trust fund should be non-complex, it should be easy to administer, and that payments should be made quickly where they're required. And in fact, the procedures were set up following meetings with the beneficiaries. So that was very important. They were consulted on how they wanted the trust fund to operate.
Now, in 2002, there were further payments made. We'll come on to that, but the tribunal that had been set up in relation to hepatitis C was extended to cover HIV. And as a result, there was a decision that needed to be made about the future of the HIV Haemophilia Trust. And as I understand it, the decision was taken through consultation with those who had been infected. Is that right? With a range of beneficiaries? Yeah,
we organised a meeting with as many of those as possible who survived with HIV, and we asked them, at that point, there wasn't an enormous amount of money left in the trust fund, so we offered them the option of closing down the trust fund and dividing the remaining funds equally between the participants, or keep it going as sort of an emergency fund. And they were very adamant they wanted it kept going.
And that's the way in which it has continued to operate again through, it continues, is this right to make one-off payments? Again, it might be for equipment, or you refer to Christmas payments.
Yeah, well, we also look very carefully at people's individual circumstances, and we make a number of payments at Christmas each year to individuals who we believe are still in particular financial need.
And there was a top-up of the amount that the trust had in 2006,
yes.
300,000 euros.
That's right.
The trust was chaired initially by one High Court judge, and then since then has been chaired by another High Court judge. And you tell us in your statement that they had met with a lot of those who were infected, but made themselves known to the community. Is that right? And how important has that been?
Both Judge Carroll and latterly Judge Murphy, we had several meetings with the members who had HIV to hear about their concerns and their issues, and also both chairs of the trust would usually attend our annual conference for the full weekend and meet members and just have conversations with them. So they really developed empathy and a sense of understanding of the real issues in the community.
And you were asked in your statement if you thought that the HIV, the Haemophilia HIV Trust, the HHT, had been successful. And you told us in your statement that you think it has been, its objectives were met. And you've identified 3 factors: trustees acting with empathy and understanding, the ability to respond rapidly, and its relatively informal structure.
Yes.
Is that right?
Yes.
So that's the HIV, the HHT. Mm-hmm. Now, the second main plank of financial support for those who were infected is the Compensation Tribunal. And so I just wanted to ask you a little about how that first...
There was the earlier 1991
I'm sorry, yes,
compensation as
yes.
well. Yes.
Yes, let's pick that up. So there was litigation in Ireland, in the same way as we know that there was litigation in the United Kingdom, which was settled in 1991, is that correct?
That's correct. We employed a legal team from 1989 and worked with them, and we were looking at the society actually funding a test case. But as this was going on and on through the course of 1990, it became apparent this was not going to see a courtroom at any time in the immediate future. And in the meantime, the number of people dying of AIDS and getting AIDS was increasing rapidly. We then saw that the compensation paid by the John Major-led government in the UK, and we decided, look, the time was right to try and settle this politically. So at the time, the minister asked the society for a submission to settle these legal cases, and we entered again into a 4 or 5 month political and media campaign, culminating in an offer of compensation in 1991.
And that resulted in what I think you described as tiered payments,
Yes.
in a way that's a similar, I think not identical, but similar to the way in which it was done in the United Kingdom.
Yes.
So if we look back at your statement, please, WITN 7418001, page 24. And it's paragraph 43. And you've set out in the previous paragraphs
Yes.
the process of the litigation, the campaign, and so on. We secured an improved offer of £8 million to be paid quickly, and with no £1 million clawback. Is that was a clawback of what had been paid to the HHT, was it?
Originally, the government offer was 7 million, and from that 7, they also wanted to claw back the 1 million paid to the HHT in 1996, and they wanted to stage the payments over a 2-year period. So, frankly, in the week between that 7 million and the improved offer, local elections were taking place a week later. We knew we had 1 more week to optimise our political and media campaign. We actually had 4 candidates running in the local elections. So we secured a better offer of 8 million and with no clawback. So in fact, it was an increase of 2 million over the previous offer, and it was paid over a course of 2 or 3 months.
And then we can see the figures that
Yes.
were agreed there. So married man with children, 101,000. Widow, 93,000. Married man with no children, 89,000. Single adult or child, 76,000. Infected spouse, 25,000, although there were in fact none. And then non-dependent relatives of a deceased man, 21,000. So if we look at the position as at the end of 1991, you have those one-off ex gratia payments.
Yes.
And then you have the operation of the HHT.
HHT, yes.
May I just ask a couple of questions at this point? First of all, the paragraph that we see on the screen uses the pound symbol.
Well, we didn't change the euro until I think 2006. So
this is punts.
punts, yes.
And at that stage, a punt was approaching parity, was it?
It was equivalent to sterling, I think, at the time.
So for the £8 million, we can, as near as makes little difference, we can read that as £8 million sterling.
Yes.
This is for a country with a population at the time of about 3.5
That's correct.
million.
Yep, that's correct.
So if to do the maths more quickly, assume 4 billion, there are 60 million people roughly, a bit more, in the UK. So in order to translate this into what would be an equivalent payment in the UK, you'd have to multiply 8 million by 15.
120.
120 million. And that was what was paid on the basis of a moral obligation,
Yes.
And nothing else.
Correct.
Do you?
And is it right to understand there was no acceptance of liability, of legal liability by
That's
the government?
correct.
Now, as your statement then describes to us, what then came to the forefront was the position of those who've been infected with hepatitis C.
Yes.
And you described that particularly coming to your attention in, I think, 1993, when there were discussions about the availability of interferon and indeed people being charged for treatment with interferon.
That's correct. Obviously, when the hepatitis C virus was identified in 1989, it became a topic which we discussed at our conferences in 89, 90, 91, 92. We were doing quite a bit of work on this, and the first treatment for hepatitis C interferon, there was actually a monthly charge for this, which we felt they should certainly not be charging to people who'd been infected through blood products supplied by the state. So we had a series of meetings with the health ministry to discuss removing that charge for people with haemophilia, and we also initiated discussions on compensation at that point.
And then if we could just put your statement back on screen, sorry, Lawrence, 74180001, and go to page 25. In paragraph 46, you say this: following many discussions, it became clear that the Department of Health were willing to concede in principle on the issue of compensation. And then you go on to talk about how the tribunal came to be set up, and I'll come on to that. But what was your understanding or impression of why it was that the department did ultimately agree to the establishment of what was initially going to be a non-statutory but became a statutory tribunal?
I think certainly those discussions, that we had many discussions with them, but it was the atmosphere was different than in 89 and 91. We were not getting the same resistance, absolute resistance, that we were getting in 89 and 91, when it was like trying to get blood from a stone, frankly. They were a bit more open to the issue, they were a bit more open to the discussion. And in hindsight, I think that's because they were aware that they had this infection of over 1,000 women with anti-D in the background, and that came to the fore in February of 1994. So I think they saw this was going to be a wider issue and they needed to deal with this.
So the department agreed to set up a hepatitis C compensation tribunal, and that became a statutory tribunal under the Hepatitis C Compensation Tribunal Act of 1997. If we just look briefly at that, WITN 7418010. So we've got the arrangement of the Act there. If we go please to page 4, we can see bottom of the page, section 3, establishes the tribunal, a tribunal to be known as the Hepatitis C Compensation Tribunal, to award compensation then, and to a class of claimants. Now, just before we look at who could claim from this tribunal, this uses the term compensation rather than ex gratia payments. So was that significant to your mind, that this was an acceptance of compensation rather than the making of a payment to dispose of litigation?
Yes, because there was no litigation ongoing at the time in relation to hepatitis C infection. And I think the word compensation was used very clearly by government. And in fact, they're not going to put the word in an act without thinking it through. And whereas in 1989, the word was banned, they would talk about recompense or ex gratia payments without admission of liability. Compensation was clearly understood to be compensation in 19.
But there was still no acceptance of legal liability by the government.
That's correct, and in fact, it's worth, I think, reiterating that the Compensation Tribunal, that the first payments under the Compensation Tribunal were made a year before the Lindsay Tribunal terms of reference were even, the discussion started, 4 years before the tribunal started hearings and 6 years before the report. So I think they had clearly I think the government put their hand up and accepted responsibility at that point. There was no legal admission of responsibility, but clearly they were paying compensation.
And if we go over to page 6, and we've got section 4 of the Act, and that tells us who could claim initially to the tribunal. So those diagnosed positive for hepatitis C resulting from anti-D, those diagnosed positive for hepatitis C as a result of receiving a blood transfusion or blood product, and then we have children and spouses, carers, and dependents. And if we just go to the next page, just to pick up something, it's in subsection 7, so it's the 4th paragraph down. A claimant shall not be required to produce to the tribunal any evidence of negligence on the part of a relevant agency or other person in respect of her or his claim. So there was no investigation by the tribunal of liability. The claimant had to establish that they had been infected through either anti-D or blood products provided by the state. But that was all they needed to show in order to establish a prima facie entitlement to compensation.
That's correct. And in fact, in the case of a person with haemophilia, just being able to show from medical records that the person had received factor concentrate, plasma-derived factor concentrate, was deemed sufficient proof. And I think, there was, in relation to negligence, if the individual believed that they were entitled to aggravated or exemplary damages, they could look for that, or instead of that, they could also, any award that they would get would be topped up by 20% from a so-called reparation fund.
And that's how we understand the reference to section 5, subsection 3 there is a reference to, if we go to the bottom of the next page, it's the 3rd paragraph from the bottom. So an award in respect of aggravated or exemplary damages may be made by the tribunal where a claimant establishes a legal entitlement to such against a relevant agency or the minister.
Yes.
So if a claimant wanted aggravated or exemplary damages, they had to establish that there was a basis for it, that was a basis recognised in law. But is this right? They could opt then for instead for a 20% uplift to their compensation.
That's correct. Any individual who felt that they were entitled to aggravated or exemplary damages could seek those as part of their hearing. If they decided not to seek that, their award was automatically topped up by an additional 20%.
And that came from something called a reparation fund.
Yes.
What was that?
It was basically a fund that topped up the awards by 20% in lieu of aggravated or exemplary damages.
But essentially a fund from the same source, from
yes,
government?
Absolutely, yes. Yeah.
And then we can take the
Well, just before we do that, can we go back to page 6, please, the list of those who can claim. Under section 4, the 4C is a child or any spouse, and D, a person who's responsible for the care of a person referred to in A, B, or C. So that suggests to me, on the language, that would include parents of children affected. Is that the way it worked?
I believe so, yes. Yeah.
You?
I skated it, sir, over subparagraph F, a person referred to in section 9. That refers to the power of the minister to extend the classes of persons who could bring claims. So if we then go back to how the tribunal operated as set up under the 1997 Act, so the claimant had to prove that they had an infection caused by treatment from the state on the balance of probabilities. And as you've explained, for those with haemophilia, that was a relatively straightforward exercise. I don't know whether you know the answer to this, because obviously your focus will have been those with haemophilia, but we have heard evidence in relation to the United Kingdom of claims being made to the funds established here by those infected through transfusion being difficult to establish because of lost or missing or incomplete medical records. Do you know whether that was a problem in Ireland for those infected through the transfusion route? Not
that I'm aware of, and certainly we had quite a lot of dealings with transfusion positive, the group who represent people who got hep C through blood transfusion. I hadn't heard that raised as an issue. My understanding again is that the government took the view that if you had haemophilia and you'd been treated with either factor concentrate or cryoprecipitate and you got hep C, that was the cause. If you could ever show that you'd had a blood transfusion, that was sufficient cause. And if you'd had received anti-D in one of a number of particular years, that was the cause.
And then is it right to understand that the claimant making the claim to the Compensation Tribunal could elect for a lump sum, so an assessment of their compensation once and for all, or for provisional damages?
Yeah, the majority elected for a one-off lump sum award, but there was also the option to take an initial award, especially if the individual was concerned about progression of liver disease or what they were facing in the future, and then there would be specific wording in their tribunal award which would allow them to go back for further compensation in specified circumstances. For example, an individual who had cirrhosis might have wording in his award saying that if he or she required a liver transplant and there were costs associated with that, they could then go back to the tribunal for a further award. So I think a number of people, also some of the younger claimants whose career path had not been set, where the impact of the hepatitis C on their medium to long-term future could not be wholly ascertained, would often have a provisional award and then go back later on for a full award.
And is it right to understand that the approach that the tribunal was required to take to the assessment of compensation was to apply the same approach that the courts would apply in a tortious claim for damages for personal injuries?
Yeah, my clear understanding is that the tribunal was assessing damages. It was as if you had won a court case and it was purely an assessment of damages. So there was no talk about liability or negligence. It was purely, it was as if a court case had been completed, yeah.
Then in terms of legal representation, costs of legal representation were met through this process?
Yes.
So those who were making the claims had the benefit of lawyers to assist them in advancing their claim?
Yeah, when the tribunal started in 1995, we had a meeting with the members who agreed to go down the route of a tribunal. They also agreed that the society should engage a legal team who would act on behalf of any member who wanted them to act on their behalf, and that we would also search out expert witnesses that many of them could use. So they really relied on us to find a legal team and to find a lot of expert witnesses. Now, of course, any individual was entirely free to get their own legal team and their own expert witnesses, but the vast majority used the same legal team and used the same expert witnesses, which actually was really helpful because they quickly developed a level of expertise and skill on this.
And then there was a right of appeal against the tribunal award to the High Court?
That's correct.
And is it right to understand that in the early years there were a number of appeals because it was thought that the tribunal assessments were too low?
Yes.
Did that have the effect essentially of raising them overall for the future, or has the need to appeal to the High Court continued to occur regularly?
It continues, perhaps not to the same extent. I mean, when the vast majority of appeals to the High Court resulted in a significant increase in the award. So I think that did start the tribunal thinking in terms of giving higher awards. So perhaps the number of appeals diminished, but there are still appeals.
Now, this obviously covered hepatitis C only, but in 2002 the tribunal's remit was extended to encompass HIV.
Yes.
How did that come about?
In 2002, we had an election coming up again, and we'd had the hearings of the Lindsay Tribunal, including the very powerful public testimony of members. During the course of the tribunal, and in the 2 years leading up to the tribunal, and during the course of the tribunal, we had constant meetings with government on various issues. But one of the things we was pressing for was, look, we felt that the 1991 awards, while very, very welcome at the time, they were not fair and equitable compensation for people who got HIV. We felt really that those individuals had been shortchanged, and in particular, the families of those who had passed away prior to 1991. So it basically came about, I think, as a result of our discussions with government and, frankly, the public impact of the very powerful public testimony at Lindsay.
And so if we go back to your statement, so WITN 7418001, pages 28 to 29. We start at the bottom of page 28. We can see there was an amendment to the 1997 Act through the Hepatitis C Compensation Tribunal Amendment Bill 2002. And then if we go to the next page, you've listed in paragraph 59 those who could apply for compensation following the amendment. So similar to what we've seen previously, but now encompassing HIV and the children or spouses of those infected with HIV, dependents and carers, HIV as well as hepatitis C.
Yes, and I think the significant part of that for us really was, if you look at section E, that the widows or dependents of those who had died. So the individual was no longer disadvantaged by the fact that they had passed away prior to the 1991 Act. Their families were getting the full compensation that they would have been entitled to had they survived to that point.
And then if we go to the next paragraph, you tell us also that new areas of claim were introduced under the 2002 Act. So yes. Child, spouse, father or mother of those who died could claim under loss of society or psychiatric injury, including post-traumatic stress disorder. Partners or spouses of those infected could claim under loss of consortium. Children or spouses of those who died could claim for loss of society, so loss of the care, companionship and affection. Dependents could also claim for aggravated or exemplary damages, where there was a legal entitlement that could be established. And these extensions covered both HIV and hepatitis C.
Yes, correct.
So the significance of the 2002 Act is this right, is twofold. First of all, it establishes or extends the rights that were conferred by the 1997 Act to those infected through HIV, and then it provides for a wider range of types of claim that's applicable to both those infected with hepatitis C and those infected with HIV.
That's correct. And bear in mind, however, that all of those infected with HIV were also co-infected with hepatitis C. Yes. So they had been compensated previously through the 91 settlement, but also through the 1997 Hepatitis C Compensation Tribunal Act. But this broadened it really to give more compensation to people with HIV, and particularly to the families of those who had passed away.
In terms of assessment for loss of earnings, which is one of the heads of claim that can yes. be advanced to the tribunal, do you know how the tribunal typically assesses the loss of earnings?
I think that they bring in a number of expert witnesses. They look at the person's educational record. They do IQ tests. They look at the career path they may have had without hepatitis C. There may be opportunities that the individual may have had to pass up on due to the hepatitis C or HIV. So it's basically based on an assessment. There might be an educational psychologist, a couple of expert witnesses.
And then in terms of those who are bringing a claim as a carer,
yes.
Effectively for the care that they will have provided gratuitously to a relative, how is that cost of care assessed? Do you know?
I can't answer that.
No. In terms of the aggravated and exemplary damages, or the 20% uplift, have there been many cases in which claimants have opted to try and establish an entitlement to aggravated or exemplary damages?
Not that I'm aware of, no.
So claimants have typically gone for the 20%
yes.
uplift?
Yes.
And then, in terms of who sits on the tribunal, I don't mean by name, but what are the kind of what kind of individuals are appointed to the Compensation Tribunal?
They tend to be barristers, all of them.
How important has the availability of legal representation been for the success of the tribunal scheme, in your view?
Vital. I think the availability of legal expertise and expert witnesses has been absolutely vital, because if you have across the board payments, as we had in 91, then you really don't need that. But when you're having an individual assessment, each individual's circumstances are going to be different, their experience is going to be different, their life with hepatitis C or HIV or both is going to be different. Its impact on their life is going to be different. So I think you really need an expert team to put that in place. It's a legal process. So, the vast majority of individuals would have no idea how to approach that. and there's a lot of structure involved in terms of putting the case, getting it prepared. So I think you do need a legal team, you need expert witnesses, and frankly, their costs. It's been very, very helpful that their costs have been borne by the state as part of the process.
You set out your view in your statement that the tribunal has been a success.
Yes.
And again, you've identified, I think, a number of factors. One, the availability of excellent legal support. Another, the availability of excellent expert witness support. You've also identified the non-adversarial nature of the tribunal, although you suggested that there might have been a shift in that regard. Can you just help us understand a little more about that?
It's very daunting for individuals with haemophilia who have been exposed to HIV, hepatitis C, to have to stand up or sit down at a legal hearing and make their case. So even preparing for a non-adversarial hearing was very, very difficult for many of them, because it means revisiting all the trauma, all the issues over the years. It was really helpful that from day one, the tribunal was sympathetic in terms of the way that the individuals were dealt with. It wasn't adversarial in terms of the questioning. They would, of course, there would be questions. They would question the figures. They would question some of the financial statements and so on. But it was non-adversarial for the most part. That has continued for the most part. Now, in the last couple of years, now the vast majority of cases, primary cases, have been heard. My understanding is the last year or two, during COVID especially, it's become a little more adversarial. They're trying to limit the number of witnesses. Obviously, they're doing virtual hearings and they're questioning more. But I think for the vast majority of our members going through the tribunal, it was genuinely non-adversarial.
And just so that we can understand the typical pre-COVID process, so a written application would be submitted,
yes.
Is that right?
Yes.
And that would set out essentially the basic facts about the claimant, and then would that written application have be accompanied by supporting expert evidence?
Yes, there'd be a written application. There'd be proof from the medical records that the individual had been exposed to hepatitis C or HIV through blood products. There'd be a summary, I guess, of their medical records. There would typically be a report from the hematologist who treated them and the hepatologist or infectious disease consultant who were treating them for HIV or hepatitis C, respectively. There would be, and usually the individual going to tribunal would be asked by the legal team to draft basically an essay on the impact of hepatitis C or HIV in their life. They would draft that. That would be included. There would be reports on loss of earnings. There would be reports on the impact on their life. There would be a report from an educational psychologist and also a counsellor who was specifically employed by the legal team. There'd be a psychological assessment. So there'd be quite a lot of reports going in.
So those would all be submitted to the tribunal.
Yes.
Would there then always be a hearing in every case, or could an assessment be made on the basis of the written material?
I'm not. I think a hearing was in every case. There was a hearing.
And in terms then of the structure of that hearing, there would be the claimant, their legal representative. Would it always be necessary for all the experts to come and give oral evidence? Or
No, not necessarily. Very often the experts' written evidence would be read into the record and taken as read.
And would it be right to understand that there would be no other side represented? There would be no opposition to the claim, or was there someone there from representing the department or the government? Or?
Well, there was usually somebody there from the Department of Health, I guess, keeping an eye on the public finances. But that was it, really. There was no adversarial people there, but the Department of Health usually represented the legal team, the individual, perhaps their family member. Before the hearing, there'd often be somebody from the society. One of my team might be with them outside just to help them through the day, help make arrangements, and so on.
And to what extent did the individual have to give evidence to the tribunal in the hearings? Was that always the case?
It wasn't obligatory, but the vast majority of cases they gave evidence.
And so would the tribunal be composed then of one member? There'd be a single lawyer.
Usually three. Usually three. Yes. Yeah.
And they would ask or could ask questions. Yes. But did whoever was there representing the department ever did they play an active role in the proceedings?
They did at
asking
times, yeah.
questions?
Yes, they did, yeah. But the questions we usually directed to the legal team or to the expert witnesses, but very rarely to the individual giving evidence on their own behalf.
And would the department make competing submissions? So if you've got the claimant's representative making a submission as to how the loss of earnings should be calculated and what figure the tribunal should award, would you have the departments making submissions to say, no, it should be a lesser figure?
Not that I'm aware of, no. You could perhaps check that with the legal team we had, but not that I'm aware of, no. I think they may question the submission that was made, but they wouldn't normally submit an additional submission of their own.
Now, in terms of the success of that process, in addition...
Just before we go to that, can I ask another question about the process? What you've described is very similar to a court assessing an amount of compensation, with one exception. In a court, as Council has pointed out, there are, of course, two sides, just as there are in your tribunal, where the Department of Health has an interest as the paying party. But there's very often, if the issue is just, I say just, the amount, there can be settlement of a claim beforehand. There was, of course, settlement of your litigation in Ireland beforehand. Is there any history of the department saying, well, we've read the written submissions, we're making an offer, and the individual saying, well, that offer looks good to me?
No.
So there's no settlement process in this at all?
Not that I'm aware of, no. I haven't heard of that at all.
You?
In terms of the success of the scheme, as well as the features you've identified, would it be right to understand that perhaps the major hallmark of success has been that it's resulted in the payment of substantial amounts of compensation to those who were infected and whose lives were devastated as a result? So they have received an award which is deliberately designed to compensate them for their losses.
I think that's fair. But also I think I wouldn't underestimate the importance of the individual having their day in court, having their hearing, having their individual circumstances investigated and looked at and decision made, as opposed to just being part of a group.
So it's an element of individual recognition.
Yes.
The recognition of the impact there has been on that individual's life.
Yes.
In terms of the disadvantages of the scheme, would it be right to understand that the major downside has been the length of time it has taken for some cases to be finally resolved? Yes.
I mean, I think the process has been very good for the vast majority of people, but some cases have taken several years to get to a hearing. If the individual who was infected was a child, then you can't really ascertain their loss of earnings or their future potential career possibilities for many, many years. So there may be a provisional award and an award later. And that has meant that the process has taken quite a long time for some people. And, even though it's a very good process, it does delay closure. So until an individual is finished entirely with the Compensation Tribunal, it's kind of hard to bring some closure to the issue. So I think that's the big disadvantage, is the time required.
And has there been any expressions of dissatisfaction on the part of those who have made claims that you're aware of? Or broadly speaking, have those who participated, made their claims to the tribunal, been content or acceptant of the outcome?
Well, I think where there was any level of dissatisfaction, the award was appealed to the High Court, and in the vast majority of cases, that resulted in a significant uplink to the award. And in some cases, in 1 or 2 cases, it was actually appealed to the Supreme Court on a point of law. So I think in terms of the amount, there was very little dissatisfaction. I think people genuinely felt that this was fair and equitable compensation. The dissatisfaction, where I've heard it expressed, relates to the length of time that the process has taken for some individuals.
There is obviously no such thing as a typical case, but is there a typical length of time that it's taken for those who were directly infected, so the primary cases, not the secondary cases, and who are infected as adults. So if we leave aside the additional complications in terms of time that might arise in relation to children, if they were making a claim in the late 90s or throughout the 2000s, once it was extended to HIV, do you have any sense of how long typically from the making of the claim to the tribunal award? How long a period
I mean,
of that?
an educated guesstimate would be a year to 18 months. Some cases significantly less than that, some cases significantly more than that.
May I ask, are there cases continuing to this day?
Yes, and they tend to be primarily secondary cases, carers, family members, maybe loss of society, loss of consortium, psychiatric injury. So the vast majority of the primary cases have been dealt with quite some time ago.
But as far as the secondary cases are concerned, or for that matter, those delayed primary cases are concerned, there will have been people who are claiming today, whose claims have not yet been decided or determined, who will most probably have suffered some financial loss. And that financial loss will have been unrecompensed during the period that they've been waiting for the assessment, will it?
I'm not sure.
So there's, it's really allied to my question about settlement is the question of whether there is any way of, or there is practice of awarding anything on the interim, on the basis that the claim must be worth at least this, and we're really talking about the rest.
No, I'm aware of the interim payments made here, Sir Brian, and I think that was greatly to be welcomed. And I think if we were starting off again at this point, it's 20 years later, and our population is 20 years older than they were when compensation was awarded in 2002, I'm sure we'd have gone for interim payments initially as well, because there can be a long period of time before the final case is heard. So I think our system has worked very well for our members, but I think in looking at this, I think it is wise to reflect on the potential for delay in hearing individual cases.
So the system works well for the reasons you've given, but it's not without the opportunity to, without the potential for improvement.
Yes.
Thank you.
And Brian, that anticipates what was going to be my next question to you, which was if you were setting it up again, would there be any differences that you would make? One you've just referred to would be the power to make interim payments. Are there any other ways in which, if you were starting from scratch again, you would change what's been done? Or?
When we were starting from scratch, I mean, I have to say that in the first instance, we were more in favour of ex gratia payments because we were concerned about a very long, complex system. Now, as it turned out, we were wrong. The individual assessment was better for members, the awards were better, and they got more closure afterwards. If I was starting again, and it's 20 years later, because bear in mind, this was 1995, it's 27 years later, and it's a much older population. I'd be very concerned about the age profile of the people claiming. So I think I'd be looking at a system where I'd be looking for significant interim payments, significant upfront payments, and then a fairly quick individual assessment if you're going down that road. I think, as I said, the majority of cases were heard in a year to 18 months, and I think that should be the benchmark, at no more than that.
I'm going to move now to a separate issue, which is the Health Amendment Card and the Health Amendment Act, or Health Amendment Card Act, I think it is. Can you tell us, first of all, in broad terms, how the Irish healthcare system works and what a medical card is?
Well, a medical card is a card which gives an individual free access to public hospitals, to general practitioners, and it's means-based. So it's typically if you have a relatively low income or a lot of dependents. Generally in Ireland, if you don't, now for haemophilia, you have a separate card called a long-term illness card, which covers the haemophilia-related costs, such as factor concentrates, ancillary supplies. They're all paid for by the state. But for people in Ireland without a medical card, then you pay for your, unlike the UK National Health Service, you pay for your GP's visits, you pay for your prescription drugs. And we have a two-tier healthcare system. We have the public hospitals, which are free for the vast majority of the population, or you can also have private health insurance. There are private hospitals or private beds in public hospitals. So it's a mixed two-tier system.
Now, you've told us in your statement how the Health Amendment Act card came about. Can you just summarise for us what led to the campaign for that scheme to be set up, and what you think swayed the government and influenced the government into setting it up?
That was not a hard battle. Unlike the compensation battles, that was not a hard battle. I think the fact that you had a couple of hundred people with haemophilia, you had several hundred people who'd been infected through blood transfusion, you had in excess of 1,000 women who had been infected through anti-D. All of these groups collectively wanted access to better healthcare. So I think it was very much a case of coming up with a solution for, in a sense, in relation to the total population, a relatively small group of people, 3,000 or 4,000 people in total. So I think that's one of the reasons the card was put in place, was because the number of people who would benefit would be finite and wouldn't be increasing. So it wasn't a hard battle to have it put in place.
And if we just look briefly at the Act, WITN 7418005, please. And if we go to page 3, we've got the Health Amendment Act 1996, and we can just pick up the essence of it in paragraph 2. A health board shall make available without charge to persons who, in the opinion of the Chief Executive Officer of the board, have contracted hepatitis C directly or indirectly from the use of human immunoglobulin anti-D or the receipt within the state of another blood product or a blood transfusion, and to persons of such other classes if any as may be prescribed. And then we have set out a number of services. Now, this is limited to hepatitis C, doesn't encompass HIV.
It actually does, in the sense that, I mean, all of our members who were infected with HIV were also infected with hepatitis C. But it does cover, just look at the specifics of the Act, it does cover HIV as well, okay, through blood and blood products. So if an individual had been infected with HIV through blood or blood product, but had not been co-infected with hepatitis C, they would still get a HAA card.
Okay. And then if we look at the guide you've appended to your statement, WITN 7418011, this is a 2020 piece of guidance about the working of the card, and I think we can pick it up on page 3. Under the heading Introduction, this 2020 Information Guide to Services is for persons who contracted hepatitis C through the administration within the state of contaminated blood and blood products and are currently eligible for a Health Amendment Act HAA card. And then if we just look at the next paragraph, the new drug treatment for hepatitis C has been offered to all HAA card holders by the end of 2017, and many card holders have been successfully treated in the last couple of years. The HAA card is a lifetime card. So is it right to understand that if an individual has been successfully treated through the new treatments and has cleared hepatitis C, they still have the HAA card for their lifetime?
Correct, because they will still have hepatitis C antibodies.
And then if we go down the bottom of the page under the heading, what is the HAA card? The card is for eligible men, women and children who contracted hepatitis C from the administration within the state of contaminated blood or blood products. It's not the same as a medical card. You've told us what that is. A GP visit card, what's that?
The government have been extending free GP care to different age groups. So for people over the age of 70, they can visit their GP without payment. For children under the age of 6, they can visit. So they've been kind of contracted from both ends. We're trying to get to a point of free GP visits, but it's going to take a number of years. So that's a card that just gives you free GP visits, doesn't give you the prescriptions and other things.
And then there's reference to a drug payment scheme card. What's that?
That's if you have prescribed drugs, there is a limit that you have to pay every month, and after that you get it reimbursed, anything additional you pay.
And then this guide goes on to explain that the HAA card gives eligibility to additional HSE services on more flexible terms and conditions than the medical card. And then it explains it's for the lifetime of the card holder and it's personal to the card holder. So it doesn't extend to family members. But is there an exception to that in relation to counselling services?
Yes, the card is for the individual, but family members of a person who was infected with Hep C or HIV can avail of counselling under the card.
Well, was there a concern when this scheme was enacted that it would be unfair or amount to some form of queue jumping because it was prioritising or conferring an entitlement upon a particular group of individuals that others would not have?
No, because the 3,500 individuals had developed serious medical conditions as a result of medical treatment already provided by the state. So you're effectively giving additional and faster healthcare to people who've already had their health impaired by the actions of the state.
So it wasn't something that was has led to any resentment or any sense of unfairness from the rest of the population, to your knowledge?
No, none whatsoever.
And then you've set out in your statement, if we go back to the statement, WITN 74180001, and we go to page 33, please, paragraph 77. So you've set out, paragraph 77, the services that those who hold the HAA card receive or are entitled to receive.
Yes.
The first is open access to public hospital facilities for hepatitis C or any related condition. The card holder should not have to wait more than 2 weeks for an appointment with their liver specialist and also for their first referral to another specialty. This is generally referred to as the 2-week rule. And then if we go over the page, once the card holder is referred by the liver consultant to another consultant in a public hospital for the testing, investigation or treatment of any known or suspected condition related to hepatitis C, or any condition which, while not related to hepatitis C, requires special treatment or care as a result of the patient's infection with hepatitis C, they will be given priority appointment within 2 weeks of the first consultation. And then subsequent appointments, you'll go on to say, with a speciality outside hepatology, are done on the basis of medical need, and there's no 2-week rule applicable to that. So I just want to get a sense of how this works for the individual who has hepatitis C. This 2-week rule, the entitlement to be seen within 2 weeks, in practice, at least prior to the pandemic, did that normally take place?
It did for a number of years. I would say it worked reasonably well until such time as the direct-acting antivirals meant that the vast majority of people were able to clear hepatitis C infection. Now, prior to that, people with hepatitis C might have the need fairly urgently for a consultation with a dermatologist or a rheumatologist or a cardiologist, and this was designed that they weren't waiting in a long queue for that. So their hepatologist could say, okay, this individual, I want them to see a rheumatologist fairly quickly, so they'd get in within 2 weeks. It worked relatively well, but I think even before the pandemic, from I'd say maybe 2014, 2015, once the vast majority of people had been offered treatment for hepatitis C, it started to unravel somewhat. So that's one aspect of the card that doesn't function very well, simply because of the pressure on the hospitals, on the pressure on hospital beds. And so I think also the requirement for people to see additional specialists outside of hepatology has diminished with successful treatment.
And then if we continue through the list of services, so if we go further down the page, we've got access free of charge to a registered GP of the individual's choice and to all GP medical and surgical services for all medical conditions, and you've explained how that is different from the position of the ordinary medical card holder. Top of the next page, entitlement to all necessary routine and emergency dental treatment. And then paragraph D, free hearing tests and hearing aids, and entitlements to an eye examination, spectacles, contact lenses and so on. Then certain aids and appliances, and you've given some examples there, walking sticks, frames, wheelchairs, etc. Access to physiotherapy when prescribed, and then a home nursing service available in respect of all conditions affecting the health of eligible people. How does that work, and how much recourse to it have those who hold the cards had to have, do you know?
I think most card holders have not had recourse to that, but when they have, it's very, very significant. In some cases, 24-hour nursing care. So we've had a number of members where, certainly when they're extremely seriously ill, perhaps near the end of life, that they will get 24-hour nursing care at home. It works really well. We had a case in the last couple of weeks of one of our members who was being discharged from hospital, extremely sick, and within 24 hours we had 24-hour nursing care for him at home. So really, there's a clinical nurse coordinator who works for the HA card scheme. She will assess this very quickly. The individual or the hospital will contact her, or if the individual contacts us, we will contact her. There's a very good liaison between all of us, so really we can get this in place very, very quickly.
And then if we go over the page, we can see the list continuing: access to chiropody and podiatry services, access to complementary therapies, and that includes massage, reflexology, acupuncture, aromatherapy, hydrotherapy, and they're set out in the guide that we looked at a few minutes ago. And then access to counselling services for the affected individual, and then we see they're also available to relatives or carers. What's the role in relation to all of these services of the liaison officer?
It's crucial. You've got about 3,500 cards issued in a population of 5 million. Now, most GPs won't have seen the card. A lot of pharmacists won't be familiar with the card. So the role of the liaison officer is to ensure that the individual gets the services which they should be getting. I would say their role has been really important. There are 10 of them. They cover geographic areas. So each individual who has a card will have an assigned liaison officer. So if they have any difficulty getting access to any of the services, they contact the liaison officer and their job is sorted out pretty quickly. In some cases, the individual will contact us. Most weeks, we're dealing with at least one query from a member about something to do with the HA card, and they're usually in the grey areas where this may or may not be covered. And I have to say that we found the liaison officers to be extremely good to work with. They cut through a lot of the bureaucracy. I would say that the scheme has been extremely successful. It would not have been successful if we didn't have the liaison officers.
And then if we just go to the next paragraph, we can see here the reference to home support services.
Yes.
And now, as I understand it, this is something that's distinct from the home nursing service.
Correct.
That's meeting clinical needs, care
Correct.
provided by or arranged by nurses. This is more along the lines of domiciliary support, assistance within the home with household tasks. Is that right?
Yes.
And again, what's the take-up and importance been of that particular service?
There's been a significant take-up of that. A significant number of our members certainly would have a home worker who comes in and does tasks around the house: cleaning, cooking, ironing, gardening. They would receive a defined number of days per week. They can either, the health service will employ a home worker centrally and assign them if they wish, or if they wish, they can employ them themselves and be reimbursed for the cost of that, because the latter is necessary because of confidentiality. I think confidentiality permeates everything in relation to hepatitis C in the card. People are very concerned about maintaining their confidentiality. So in some cases that has meant that they will employ somebody locally themselves, and then the cost will be reimbursed by the health service.
Now, you were asked in your statement whether you thought the HAA card was a success, and you've said unequivocally yes. Why is that? Why is that your view?
I would have said if we were speaking back in 95, 96, 97, our members were much more concerned about compensation on these issues and the forthcoming inquiry than they were about the HAA card. But when I look back on it now with the benefit of hindsight, the HAA card has been absolutely crucial because it gives people a prioritised access to a lot of the healthcare and services and support they need on an ongoing basis. It has been invaluable for people when they run into trouble health-wise, and when people are at the point where if they are getting near the end of their life, it has been absolutely amazing in terms of the help and support we can put in place very quickly.
And same question as with the Compensation Tribunal. If you were setting up the scheme again from scratch, would you make any changes to it, or has it worked in the way you would have wished it to?
No, I think I wouldn't make any changes. I think it works very well. I would clarify perhaps the 2-week rule and just, include it if it's going to work and don't include it if it's not going to work.
That leaves the question of how long, doesn't it? It leaves the question of how long.
How long?
How long one may have to wait for the various things that would be covered by the 2-week rule. Because if you don't have a period of time, you've no yardstick to judge the length of delay.
But in fairness, there's been a degree of pragmatism in the way that this is operated by the liaison officers. So I'm aware of cases among our members where they need to see a specialist in a particular area they're concerned about. They will go privately, even though the card doesn't pay for that, and the card has actually paid for that. So there are cases where if you can make a case that an individual needs to see a specialist within a short period of time and they have to pay for that, then they can seek reimbursement. And in many cases,
and without a 2-week rule, that would not be easy to achieve, I imagine.
No, I think it's perhaps not. I think the 2-week rule is well intentioned. It just hasn't worked for the last number of years because of the overwhelming pressure on the health service.
Well, I can see that in some societies it may be aspirational rather than realistic, but the issue may be finding the right number of weeks to represent the balance.
Yeah, and you'd also perhaps run into the problem where some consultants will resent being told that you need to see a particular patient, a group of patients within 2 weeks when they have a long waiting list. I've never met a consultant who resents being paid. So that removes the problem.
Yes.
So I know the time. I probably only got about another 10, 15 minutes of questions because there's really just one further topic I want to cover, which is that of insurance. So we could either continue now or take a break and come back after the break.
Well, it may be more sensible to continue. Let me explain and ask Brian what he would prefer to do. Normally at this stage we'd have a break, about half an hour, so people can have coffee, and in particular for those who are listening, to give them a chance to have a break, bearing in mind the effects or lingering effects of some of the conditions which some of them may have. But the general practice is after Council has finished the questions from the inquiry, there is an opportunity, it's prescribed by law, for those who are represented by legal representatives to have those legal representatives suggest to Council questions which it is appropriate should be asked. And that process needs a bit of time, obviously, because they hadn't yet heard what you had to say in answer to the earlier questions. So if we go on for 15 minutes now, there'll be a break of perhaps longer than half an hour. And then there'll be the last session for today, and you'll be finished, I would suspect, probably by lunchtime, but I can't tell you how long, because it depends how many questions there'll be, and there may be quite a number. The alternative is breaking 15 minutes break for 15
No, please proceed.
half an hour or so.
I'm fine to proceed.
Very well.
Okay.
And I think we're still within the period of time that's acceptable for the stenographers.
Well, unless there's any objection coming through from the stenographers, who also have to be borne in mind,
Absolutely.
Let's proceed.
So the third area I wanted to ask you about in terms of the state's response in Ireland, Brian, is in relation to insurance. In 2006, something called the Hepatitis C Insurance Scheme was set up. What led to that being set up at that point in time?
Well, if I go right back to 1986, we first raised concerns about the inability of people with haemophilia, with Hep C, or with HIV at the time, to get life insurance or mortgage insurance. We actually had a meeting with a government minister in 1987, and as you saw on the AIDS, haemophilia, and the government booklet, we put this in our list of issues for the government in 1988, and they didn't deal with that at the time. They set up the HHT. So we were always conscious that even before HIV and hepatitis C, it was difficult for people with haemophilia to get life insurance or mortgage insurance without a loading. Once you add in HIV and or hepatitis C, it becomes from very difficult to impossible. So really people were in the situation where they couldn't get life insurance, they couldn't get mortgage insurance, which in some cases meant they couldn't buy a house. This issue was in the back of our minds at all times. So when we were discussing all of the issues in the 2 years and 3 months it took us to agree the terms of reference for the Lindsay inquiry, we discussed all sorts of issues. This was one of the issues that we kept raising: insurance, mortgage insurance, life insurance, mortgage insurance. And then around the time of the 2002 Act, we again raised the issue. So the government agreed that they would set up a steering group with the organisations representing those who had been affected, with our legal teams, with the department, to try and see if they could come up with a scheme. And that took at least 4 years to get that up and running, and that culminated in 2006 Act.
And so we had the Hepatitis C Compensation Tribunal Amendment Act 2006, which set up the scheme, and I think we've got some regulations, but I don't think we need to look at those. If we go back to that guide that we were looking at earlier, because it's got a section on insurance, and I think it might be a convenient way of picking it up. WITN 7418011, please, page 23. So we've got the heading insurance scheme, travel insurance, mortgage protection insurance, life insurance for persons who were infected through blood or blood products within the state. And then we've got the general rules for the insurance scheme. And if we just look at the whole page for a moment, we can see there's a heading bottom half of the page: eligibility to avail of the insurance scheme. You must have an eligibility certificate. And then there's a description of how you get that. And then in terms of getting an eligibility certificate, if you've got an HAA card or you've been awarded compensation by the tribunal, you get the eligibility certificate automatically.
Yes.
If you don't fall within either of those categories, I don't know if there are any who would, you would then have to make out a case for eligibility.
Yes.
But essentially, it's proof of infection or acceptance that you were infected and infected through blood or blood products.
Yeah, but you don't have to keep proving it. So as you say, if you have a HAA card or if you got an award for compensation tribunal as a person with Hep C or HIV, then you can take out the insurance.
And then if we just go back to the top half of the page, so we can see the 3 types of insurance under the scheme. So life insurance, mortgage protection and travel insurance. Can I deal with the life insurance first of all? How does that work in practice? What does this give people that they would otherwise have struggled to get?
As I said, somebody with haemophilia without HIV or hepatitis C is often loaded for life insurance. If you have hepatitis C, if you can get life insurance, you will be severely loaded. If you have hepatitis C and HIV, you will be deemed to be uninsurable. You won't get life insurance. Now, the scheme, first of all, you can take out life insurance up to your 65th birthday. But if you took it out in the first year of the scheme, we'd negotiated that you could be insured up to your 75th birthday. So, in fact, for the first year after the implementation of the scheme, I was like an insurance salesman trying to get as many of our members to take it out as possible, because you got an extra 10 years of cover. And also, if you took it out after the first year, if you were under the age of 30 or over the age of 50, there was 1 or 2 years until you got full cover. So it was really the optimum time to take out the insurance was in the first year of the scheme. What it covers is you will basically get life insurance up to, I think it's 7 times the average income, or up to a maximum of about 525,000 euros. You'll be able to take out life insurance at the same premium for a person of your age who's perfectly healthy, who doesn't have HIV, who doesn't have hepatitis C, who doesn't have haemophilia. The only difference is if you're a smoker. They load that along the board. So if you've got a 50-year-old man with co-infection, with haemophilia, with joint arthropathy, with kidney disease, with liver disease, he will get insurance at the same rate as a perfectly healthy 50-year-old. So it makes insurance attainable for people.
And is this underwritten by the state?
Yes, and in fact, so what happens is we have two insurance companies who provide policies under the scheme. They have to be accepted by the scheme, and then the insurance company will, they'll do an evaluation as they normally do, and then they will quote a premium. And the premium, there's a premium quote to the individual, but then there's also a premium quote to the government. So, for example, with somebody who has hepatitis C, the premium to the individual is the premium for a perfectly healthy person. The premium, there's an additional premium then to be paid by the insurance scheme on behalf of the government. If the individual is co-infected and is deemed to be uninsurable, effectively the government becomes a reinsurer. So they will still get the policy from the insurance company, they'll still pay the same premium as a perfectly healthy person, but in effect there's an arrangement between the government and the insurance company about who pays if and when the person passes away.
And just sticking with life insurance for a moment, how important has that been for your members and others?
I think it's been very important because it means that individuals can take out life insurance at a reasonable cost. They can provide for their family, their dependents in the event of their death, up to the age of 65 or 75, depending when they took it out. And it also means that if they do get compensation, they can actually use that compensation to live their life and not necessarily have to salt it away to provide for their family in the event of their death.
And then the second type of insurance, the mortgage protection insurance, for a new primary home or repair, renovation or refurbishment of current primary home, does that essentially work in the same way?
Yes.
But you've told us in your statement that the uptake of that has been relatively low. Why? Do you know why that is?
I think there was a reasonable uptake in year one, but after that, people haven't been taking it up. I'm not sure why. It's surprising. I mean, to me also with the life insurance, I would have thought that practically every person, with Hep C or HIV would take out life insurance under the scheme in year one, and a lot chose not to. So the mortgage protection insurance was. The uptake was being quite slow or low. Also, in year one of the scheme, there was a remortgage, so you could actually take out additional insurance for $100,000 if you had an existing mortgage. Again, there was very little take up on that.
And then the third form of insurance is travel insurance. Again, is that essentially done on the same way? So you're insured in the way you would be if you were in perfect health, and then the increase is effectively underwritten by or paid for by the state.
Yes.
And how important has that been?
Extremely important. I think the vast majority of cardholders take that out, especially now we've started travelling again post-COVID. But it's really important. It means that the individual and their family can take out travel insurance. And that's been very, very useful. And it gives them low-cost travel insurance. And I get queries all the time from people with haemophilia who don't have HIV or hepatitis C, who are concerned because they find it expensive to get travel insurance. So ironically, if you're in Ireland and you have HIV or hepatitis C, it's easier to get travel insurance, life insurance, and mortgage insurance than if you just have haemophilia.
And you told us how this was something raised back in the 80s, and it took all the way through to the discussions following the 2002 Act and the Lindsay Inquiry report for this to eventually come to fruition. Was there resistance on the part of government, or was it just effective? Was it just ignored? Or?
There was a little bit of resistance initially, but again, as the personal stories come out from Lindsay, as the public awareness increased, and government were genuinely sympathetic, and their response was sympathetic. So there was a willingness to explore this, but from a practical point of view, it was still quite difficult to put it in place. So we had 4 legal teams, we had a team of actuaries, we had a couple of insurance specialists and brokers, we had the Department of Health, we had the 4 organisations. I think we had 35 excruciatingly long steering committee meetings over those 4 years. I know my colleague, our former chairman, who was at those meetings with me when he left the Society board a few years later, and I asked him back about 2012 to come back on the board, he made me promise he'd never have to go to an insurance meeting again. So it was a lot of work to put this one in place, simply because of it was a novel concept. I don't think it had been done before. So and the insurance industry are, they're very conservative in the way they look at things. So it took a lot of work to put it in place.
And then just a final question from me for now, Brian. Those three types of scheme that we've been looking at, so the provision for compensation through the tribunal, the HAA card, and then the insurance scheme, these are all measures that have been taken by the state.
Yes.
In recognition, would this be right to say, of the suffering that and disadvantage that individuals have experienced through treatment at the hands of the state, as well as the obvious benefits of the schemes themselves, the provision of financial assistance, access to health services and so on. How important has it been for those who were infected in Ireland to that very fact of state recognition that something had to be done?
I think hugely important. When I look at the Lindsay inquiry, and I think a couple of things come to mind, the personal testimony was hugely important. The public understanding of what had happened to the community was very, very important. And the public understanding was frankly helped by very responsible media coverage in the Irish media. All of the main daily newspapers covered it, in great detail. I think the apology from the government after the report came out, the compensation which was put in place without having to wait for the inquiry report, the HAA card, the insurance, the tax concessions, these were all really important in an overall view that, look, this happened, this was an awful thing that happened to you, we're really sorry, and we're going to make it up to you in any way that we can.
Thank you. So those are the questions I have for Brian, but if we could now take our break and afford the opportunity to call participants to suggest further matters they might want me to ask.
How long a break do you think you might need?
Well, I think probably our normal half an hour break should suffice, because a lot of the questions I've asked have reflected the suggestions already made to me. So if we take half an hour, but if I need longer, sir, I will...
Well, what I'll say is, in these circumstances, is my usual. We will take a break and come back not before 12 o'clock. It may be later. If so, we'll let you know, but otherwise not before 12 o'clock.
And so the normal advice to the witness... No, fine.